Welcome to the debate. Today we're diving into, well, really one of the most foundational and persistent controversies in American federalism, the scope and meaning of the 11th Amendment.
Exactly. This amendment ratified back in 1795 with what historians called, vehement speed. It came as a direct response to the shock of surprise from the Supreme Court's decision in Chisholm v. Georgia just 2 years earlier.
And that shock was seismic, truly. The court in Chisholm essentially held that a state, despite its sovereign status, could be dragged into federal court by a private citizen from another state. The 11th Amendment was the immediate constitutional fix, really, designed specifically to undo that result.
And the core controversy, the one that's really defined, the last century or more of jurisprudence, is whether this amendment represents a, let's say, narrow textual repeal of specific diversity jurisdiction, defined by the parties involved, or whether it actually embodies a broad, fundamental principle of state sovereign immunity that's just inherent to the federal structure itself.
Right. And I land on that latter view. I see the 11th Amendment as merely an illustration, you could say, of a deeper constitutional truth. I'll be arguing for the broad, structural view of state sovereign immunity, a view that was really cemented by decisions like Hans v. Louisiana and later pushed, I think, to its logical conclusion in Alden v. Maine.
And I believe we really must stick to the text here. The amendment feels like a specific, almost surgical strike against a particular type of party-based jurisdiction authorized under Article 3. Its sole purpose, initially at least, was overturning Chisholm. So I'm arguing for the narrow textual reading.
My core position, really, is that state immunity from suit without consent is a fundamental postulate of our constitutional design. It's a pre-existing right, something the states retained, not something the 11th Amendment created. The adoption of the amendment was, well, simply the nation's prompt recognition that the Chisholm Court had fundamentally misunderstood the original Article 3 grant of judicial power.
That's a powerful foundational argument, I'll grant you. But if immunity is this pre-existing structural right inherent to sovereignty, why did the framers write an amendment so narrowly focused on specific plaintiffs? The text explicitly bars suits only by citizens of another state or by citizens or subjects of any foreign state. It reads like a specific repeal, doesn't it?
Well, the text was insufficient, certainly. You could argue that. But the principle behind it, I think, was clear.
That insufficiency became, immediately apparent once the court faced federal question jurisdiction cases, specifically Hans v. Louisiana back in 1890. If the text alone controlled, Louisiana should have been suable by its own citizen under federal question jurisdiction, right? Because the text says absolutely nothing about federal question cases or a state's own citizens.
Hans, I believe, understood the underlying principle established in 1795 was really about preventing the indignity and the loss of sovereignty that comes from being made an unwilling defendant by any private individual in federal court, whatever the jurisdictional basis. Hans correctly restored that original understanding, recognizing that allowing a state to be sued without its consent was, quote, a thing unknown to the law at the time of ratification. The structural immunity therefore limits the judicial power established in Article 3, even in federal question cases brought by a state's own citizens.
I appreciate the defense of Hans, I do, but it kind of proves my point about judicial overreach, doesn't it? The court in Hans really had to strain the constitutional language far beyond its literal meaning to get that result. Chief Justice Marshall, actually, in his earlier view in Cohen's v. Virginia, seemed to believe the judicial power extended to all cases arising under federal law, even if a state was a party, and that the 11th Amendment was just about diversity jurisdiction. The fact that the court felt compelled in 1890 to expand the rule, to include a state's own citizens and federal question cases, it suggests they prioritized a perceived sense of state dignity over the clear limits of the constitutional text.
and frame the expansion in Hans as necessary intellectual housekeeping, not really overreach. The true purpose, following the Chisholm debacle, was establishing that federal jurisdiction just didn't extend to making states unwilling defendants at the behest of private parties. And we see this confirmed later, right, in cases like Ex parte New York, number 1, in 1921, where the court barred admiralty suits. Now, the amendment only mentions suit in law or equity, yet the structural principle was seen as broad enough to cover admiralty too. This immunity, I argue, flows from the structure, a postulate of inherent sovereignty, not just the limited words of the amendment itself.
Okay, with that emphasis on the structural view, it forces the court onto a kind of conceptual tightrope, doesn't it? Regarding the nature of the immunity itself. If sovereign immunity is truly a jurisdictional bar, like a fundamental flaw in Article 3 power preventing the court from even hearing the case, then how can a state logically, consent to suit in waiver? Consent can't create jurisdiction where the Constitution says it's fundamentally lacking. The fact that states can waive immunity strongly suggests it's more like a waivable privilege or a defense, not some innate limitation on Article 3's subject matter jurisdiction.
That's a fair articulation of a core definitional paradox, certainly. And the court has struggled with the terminology, no doubt. At times saying the immunity sufficiently partakes of the nature of a jurisdictional bar so it can be raised late in a proceeding. However, the operational impact, I think, is clear. Whether you label it a bar or a waiverable privilege, the principle of sovereign immunity imposes a constitutional limitation on the exercise of federal judicial power under Article 3. And, well, I think that leads us pretty directly, doesn't it, to the whole question of congressional power.
Indeed.
Because from your perspective, this immunity is a constitutional limitation on the judicial power. You necessarily argue that Congress, when it's acting under its Article 1 powers, things like the Commerce Clause, well, it lacks the constitutional authority to just unilaterally abrogate or withdraw state immunity. Absolutely. That was the central holding, wasn't it, of Seminole Tribe of Florida versus Florida back in 1996. Allowing Congress to use ordinary Article 1 powers to force states into court would effectively circumvent the constitutional limitations placed on the federal judiciary by this structural immunity. I mean, if the federal courts lack the constitutional power to hear the case in the first place, Congress can't just use its legislative power under Article 1 to grant them that authority. This protection of state sovereignty is, well, non-negotiable via ordinary regulatory legislation.
But see, that result severely cripples the federal government's ability to enforce national policy. I maintain that Congress's ability to withdraw immunity should be coextensive with its power to legislate. Why grant Congress broad regulatory power over the states, particularly in huge areas like commerce or labor, yet deny it the most efficient means of enforcement, which is often private citizen suits? I mean, common law immunity was always subject to legislative alteration, historically speaking.
But that seems to ignore the fundamental shift created by the constitutional structure itself.
Well, the history itself gives us the necessary counterexample, I think. Congress can subject states to suit when it acts pursuant to the 14th Amendment, specifically Section 5. That was established clearly in Fitzpatrick v. Bitzer. The 14th Amendment, crucially, was adopted after the 11th Amendment with the explicit purpose of altering that pre-existing balance of power and imposing limits on states regarding fundamental rights. So that shows the power balance can be altered by later constitutional action. Why should enforcement power regarding civil rights under the 14th Amendment be fundamentally different from enforcement power regarding, say, national economic regulation under the Commerce Clause?
The 14th Amendment is unique precisely because it represents a constitutional reordering that explicitly restricts state power. It was intended to empower Congress to enforce those restrictions. Article 1, on the other hand, deals with the national regulation of existing powers. It was never intended as a vehicle to strip states of their core sovereign status. Therefore, the structural immunity, I argue, acts as a background constitutional constraint on Article 1.
Even if we acknowledge the unique status of the 14th Amendment, the structural view still creates, I think, unnecessary hurdles. The court requires that congressional intent to abrogate immunity must be, quote, unmistakably clear in the language of the statute. This ultra-strict standard means that even where Congress clearly has constitutional power to act, the presumption remains powerfully against holding states accountable.
But that requirement is necessary, isn't it?
If you accept that the immunity is a fundamental constitutional principle derived from the structure, you must require an explicit, clear statement from the legislature to overcome that principle. The presumption has to favor state dignity and autonomy.
Well, speaking of state dignity overriding clarity, the structural view reaches what I see as its most anti-textual conclusion in Alden v. Maine back in 1999. Alden extended this principle of sovereign immunity to bar suits against states based on federal law in their own state courts.
And Alden was essential, I would argue. It prevented a profound denial of state independence.
But the 11th Amendment limits the judicial power of the United States. The text is crystal clear about which courts it's talking about. The court itself even conceded in Eldon that applying the amendment's literal text to state courts would be, and this is their word, a misnomer. By ruling that states are immune from private federal suits in their own courts, the court essentially constitutionalized a general principle of state autonomy far, far beyond anything Article 3 or the 11th Amendment explicitly commands. It turns an anti-federal court measure into a generalized anti-accountability shield.
I think that analysis misplaces the focus, though. The immunity is a pre-existing right retained by the states, and Alden correctly recognized that. The key issue isn't the venue. It's the indignity of the state being compelled, against its will, to submit to the coercive judicial power of a private party seeking to enforce federal mandates. Forcing state officials to divert resources, defend these suits, even in their own judicial system, would profoundly undermine the independence that's required for cooperative federalism to even work.
Okay, but that argument for dignity seems significantly undercut by the fact that the federal structure already permits what you're calling coercive judicial power against non-consenting states in several pretty critical areas. I mean, suits by the United States government itself or suits brought by a sister state against a non-consenting state. Those are permitted in federal court. If states ceded immunity to the federal sovereign and to each other in those key areas, it seems to severely undermine the argument that the fundamental dignity of the state is offended only by private suits.
The difference, I believe, is that when the United States or a sister state sues, the action is sovereign versus sovereign. This maintains the essential equality of the states within the federal structure. When a private individual attempts to haul a sovereign state into court, it violates the hierarchy and dignity necessary for a properly functioning federal system. Alden confirmed that this structural principle of independence applies everywhere, not just where the 11th Amendment's specific words happen to point.
And that right there is precisely the sticking point for me, the substitution of these broad, judge-made principles of dignity and federalism for the narrow, limiting text that was actually ratified by the states themselves.
To summarize my view, the prevailing structural interpretation of the 11th Amendment ensures states retain a fundamental aspect of their sovereignty. It prevents them from being, well, involuntarily dragged into court by private individuals. This constitutional protection, reflecting the determination that Chisholm was simply wrongly decided, is vital, I think, to maintaining the balance of federalism and the autonomy of state governments, as we've seen from Hans all the way through Alden.
And conversely, I'd summarize by saying that the reliance on an implied structural immunity that overrides the specific limiting language of the 11th Amendment is ultimately a judicial choice. And it's one that unnecessarily curtails the effectiveness of federal law. Adhering to the original textual limits would permit Congress, representing the national will, to hold states accountable for violating federal rights through clear, deliberate legislative action without fundamentally undermining the structural role of the states in the process.
And the fact that this tension, this pull between textual fidelity and these powerful principles of state dignity continues to fuel what feels like an institutionalized 5-4 split in modern Supreme Court jurisprudence, well, it confirms that the scope of state sovereign immunity remains perhaps the single most contested element of American federal jurisdiction today. There is clearly much more to explore in this enduring debate.